Welcome back. There have been a lot of interesting rulings and reports coming from our courts in the past week. Here's a recap of some of the top stories.
I will well and truly try the accused persons.
We'll begin with the court-martial of 97 officers and men of the Nigerian Army on allegations of offenses in the ongoing counter-terrorism operation in the Northeast. 4 lieutenant colonels, a major, 4 captains, 5 lieutenants, and 1 second lieutenant are said to be part of the officers facing the court-martial. The other 82 are of the rank and file of the Army.
To look at these conditions I've just given back.
The General Court-Martial has Lieutenant Colonel Ukwe, an Assistant Director of Legal Services at the Army Headquarters Garrison, as the judge advocate. During the inauguration of the court-martial, the president of the court said that the 97 officers and men would face charges such as mutiny, assault, absence without leave, housebreaking, conduct prejudicial to good orders, and discipline, as well as offenses relating to service property. He assured the accused persons that the court would ensure strict adherence to the principle of fair hearing and justice in its treatment of the cases before it.
Is the legal department not likely to have given legal advice?
Our senior advocate of Nigeria, Mr. Femi Falano, whose law firm is defending 68 of the accused soldiers, says the accused persons were taken to the trial court without being given the requisite document to prepare their defense. He, however, believes that there is no cause to doubt the integrity of the members of the court as the parties prepare for the trials, which is to commence on October 15. Away from the court-martial, a Federal Capital Territory High Court in Abuja has discharged and acquitted a former national chairman of the People's Democratic Party, Mr. Vincent Ogbulafo, of the entire 17 counts of fraud relating to contract verification exercise in 2001. Our second accused person, Emeka Ibila, who was then the secretary of the National Economic Intelligence Committee, NEIC, the body which was tasked with the verification exercise, was however convicted and jailed 5 years for the alleged offences. The jail terms of 5 years on each of the counts are to run concurrently. Mr. Ogbulafo was then the Minister of Special Duties, supervising the activities of NEIC, which was set up in 2001 for the verification and payment of debt owed to local contractors by the federal government. Justice Ishak Bello, in his judgment on Thursday, held that from the evidence before the court, there was no nexus between Mr. Ogbulafo, who was the Minister of Special Duties when the offences were allegedly committed, and the alleged crimes. But the judge said Mr. Ibila's confessional statement, tendered before the court without any objection from his lawyer, was a corroboration of the allegations leveled against him by the prosecution. The accused persons were being prosecuted by the Independent Corrupt Practices and Other Related Offences Commission for offences they allegedly committed in March 2001. They were alleged to have defrauded the federal government to the tune of over 170 million naira through payment to contractors for jobs that were not carried out. The Supreme Court has fixed the 21st of November to decide whether the impeachment of the Deputy Governor of Taraba State is lawful or not. Mr. Abubakar Danladi was impeached by the Taraba State House of Assembly in September 2012 for gross misconduct and engaging in private businesses. After his impeachment, he approached the court to challenge the ruling of the appeal court, which upheld the ruling of the Federal High Court in Taraba, but he was duly and constitutionally removed. In a unanimous judgment, a 5-member panel of the Justices of the Appellate Court, led by Justice Musa Abaraji, had in that hearing dismissed the appeal brought before it by the impeached Deputy Governor for lacking in merit. The court held that the Taraba State House of Assembly complied with Section 188 of the Constitution in its impeachment. The Federal High Court sitting in Lagos last week Monday vacated an order empowering the Asset Management Company of Nigeria, AMCAN, to take over the Murtala Mohammed Airport, MMA2, the old Federal Secretariat in Ikoyi, Lagos, and some other assets belonging to businessman Mr. Wale Babalaki. AMCAN, through its counsel, Ulisa Agbakuba San, had obtained the order during the court's vacation and through an ex parte application based on the inability of Baikatni to pay a 50 billion naira outstanding indebtedness to the assets managers. In the order, Mr. Agbakuba was also appointed as the receiver manager over some companies belonging to Mr. Babalaki, including Baikatni Limited and Roygate Properties Limited. In vacating the order, Justice Ibrahim Buba ruled that AMCON misled another Federal High Court judge to grant the order in the face of specific orders and pending suits on the matter. Justice Buba held that this was an abuse of court process. The court then urged parties in the suit to dialogue and embrace an out-of-court settlement to resolve their issues. AMCON has, however, appealed the order and also filed a motion to stay execution of the order made by Justice Buba Ibrahim. And we round up with the news that the coroner inquest into the recent collapse of a building within the premises of the Synagogue Church of All Nations at Ikotun, a Lagos suburb, would commence sitting on October 13. This was contained in a statement signed by Bola Akinbade, spokesperson of the Lagos State Ministry of Justice, and made available to journalists last Friday. The inquest will take place at the premises of the Ikeja High Court and will be presided over by Magistrate Oyetade Komalafe. 115 persons were reportedly killed and 131 others rescued after the multi-story building collapsed on September 12. Members of the media, families of the victims, security agencies, emergency services, and the contractors handling the church building, including Prophet Timitope Joshua, the founder of the Synagogue Church of All Nations, are expected to appear before the tribunal to testify.
Now, in other legal news, legal year ceremonies have held in so many states across the country, signaling the commencement of a new legal year. The Supreme Court also held its ceremony. One of the highlights was the swearing-in of new senior advocates of Nigeria, a former Attorney General, Dr. Oluonogoruwa, a former director of the Nigerian Law School, Professor Ojukwu, and a seasoned arbitrator, Mr. Silva Ogwemo, were conferred with the rank alongside 14 other lawyers. Now, against the background of the new legal year, some lawyers spoke to Law Weekly about some of the challenges confronting the judiciary and the need to do things differently in this new legal year.
World over, and still the case here is that of independence, of the institution, as it were. And one cannot wish away the fact that politics play a very, very important role in this respect. So it's a challenge that over the years Nigeria has been, grappling with resolving same. Unfortunately, it's the end to this challenge, or as a problem, is not, to me, is not just around the corner. We still need, as a nation, and even as a professional body, that's the Nigerian Bar Association, we still need to do a lot more, which has to do with our personal will, to get this problem or this challenge solved or resolved.
Our law still remains static. It is very painful and unfortunate. The edition of 1981, you see what regulates and determines the issue of locals or no locals in Nigeria. And I think that issues need to be critically reviewed and resolved. In Ghana, any citizens of Ghana that felt that, this is a fundamental breach of the Constitution of the Federal Republic of Ghana, that citizens is free to go to court and challenge, and the issue of constitution will not be raised. Any citizens of Ghana that felt that the issue of corruption is involved anywhere, no matter how minute that issue of corruption is, any citizen of Ghana can go to court and challenge it and say, no, this is corruption, fight it to any level, and issue of jurisdiction will not arise, will not be a bar. In Gambia, a country of less than 3 million populations, any citizen of Gambia can go to court to challenge any illegality of the any breach of the provision of the constitution or any acts of corruptions. But in Nigeria, the issues of locals will be raised, and that is why people can just come out. A personality of director of state security services will come out and tell us that somebody wanted to bribe him during the bribe the SSA during the Osun State governorship election, and nobody is asking questions. Nobody can go to court.
The area I want us to really, look into is the sheriff department carrying out execution after you must have gotten judgment. Well, when you get a judgment, it will take another 6 months to carry out execution, and the expenses, the cost of, carrying out executions. As far as I'm concerned, that is where it bothers me most. The last CJ tried as much as she could. She tried so much, and she was able to stabilize the sheriff department. But I think, all I know, that the present CJ was the head judge then, and she was aware, and I think there should be continuity in the sheriff's department.
And this is where we end today's episode of the program. These and past episodes are on our YouTube page, and you can interact with me via Facebook, email, or Twitter. I'm Shola Sheyeli. Thank you for watching.